Welcome to today's Legal One webinar on political speech for students and staff, navigating the legal minefield. My name is David Nash. I'm the director of the Legal One program, and very happy to be here with all of you to talk about these critical issues. We have a wonderful set of presenters that are with us today. This is really going to be a two-part presentation. In part one, we're going to spend some time walking through the legal framework for analyzing student speech and staff speech. In the second portion of the program, we will be having a student panel discussion that allows us to hear firsthand from some wonderful student leaders about issues of political speech and student expression. What I'll suggest as we get ourselves started, I know we do have a number of presenters, but I'm going to suggest that all of our other presenters mute themselves. We are hearing a little bit of an echo effect as I'm presenting. Thank you everyone for that. We have with us today Sandra Jakes. Sandra is our Legal One Supervisor of Legal Research and Content Development. Sandra has done a tremendous job in putting together, for the most part, our presentation today, and does that with so much of our work. So Sandra, thank you as always.
Hi everyone, nice to be here.
We also have with us NJPSA's Chief Legal Counsel, Bob Schwartz. Bob is the leader of the NJPSA Legal Department and takes a lead role in addressing member issues, the issues that arise related to principals, supervisors, and other NJPSA members. So Bob, thanks as always for being here. We also have with us Andrew Schwartz. Andrew Schwartz is NJPSA legal counsel as well, and Andrew has been with NJPSA now for a number of years representing members. So Andrew, thank you as well. We have Carol Smeltzer. Carol is also NJPSA legal counsel. Carol has great experience, was previously a school board attorney, so comes to her current role with NJPSA with a great deal of experience from that perspective as well. And we have with us John Farinella. John is the newest member of NJPSA's legal team. And John, until very recently, was the principal at Rawway High School. So comes with us with a great set of perspectives to help address these issues. So that is our legal team that will really be walking us through the first part of our presentation. In the second part of our presentation, we've got a great group of student leaders who we're going to hear from East Brunswick High School and Rawway High School. So what I'll do is just take a moment now to introduce first Dr. Michael Vanella, who is the principal at East Brunswick High School, and Mark Mondry, who heads the Institute for Political and Legal Education that operates out of East Brunswick High School. So Michael, we're very happy to have you and Mark here with us.
Well, thanks, David, and I want to thank NJPSA for offering this. This is an excellent topic and a timely topic. So it's my pleasure to be here, and I'd like to turn it over to Mark. And Mark, could you introduce the fine students from EBHS for us?
Sure, thanks, Mike. Again, I'll echo those sentiments as well. I'm really excited to be here, and I know that our students are as well. I brought with me two seniors from East Brunswick High School, Minta Sona and Jonathan Roy Varghese. These are two of our We the People team members who have dedicated their senior year to learning about civics, American politics, and government. So Minta and John, could you guys just briefly say hello and let us know how you're feeling about the conference today? Minta, why don't you jump in first?
Okay, hi, yes. I also want to express great thanks for allowing us the opportunity to talk about what goes on day to day in our schools. And I'm looking forward to talking more about it.
Thanks, Minta and John.
And also, thank you for having us today. I'm really excited to be here and engage in discussion. So thank you once again.
Great.
Great,
Thank you so much. So it's wonderful to have you. We also have a great team from Rawley High School. Dr. Michael Solosky is a social studies teacher at Rawley High School and has taken a leadership role in working with students to address some of these same critical issues when it comes to political speech and social speech. So Michael, thank you so much. And do you want to introduce yourself and your students?
Sure. First and foremost, I'd like to say this is an absolute pleasure and honor. And I thank all of the NJPSA for this fantastic opportunity that I've been really looking forward to, and I'm very excited about. I'm really excited about it mostly because of the two Rawley High School seniors that are representing Rawley High School and our Student Government Association. I've had the pleasure of knowing Jalissa Muller and Scott Nwosu. They're both seniors and four-year members / officers of our Student Government Association. And I'm so very proud of them. And I would like to give them the opportunity right now just to say something short about themselves. Jalissa, good afternoon.
Good afternoon. I'm very excited and grateful to be here and to speak about the experiences that I've had in this school.
Good afternoon, Scott, and thank you, Jalissa.
Yeah, I'm really excited to be a part of such a district, and I'm really grateful for giving me this opportunity. Look forward to talking.
Thank you, Scott.
Thank you so much, Michael, and thank you again for our facilitators and for our wonderful student leaders who we're going to be hearing from, and we're very excited to hear from in the second part of our presentation. For those of you who have ever been part of a Legal One webinar or presentation before, you've heard this, but of course we're going to be walking through a number of important and sometimes complicated legal issues. Obviously, as we do that, we're not giving legal advice. We're trying to give you the best information we have available to us. As we say that, we do want you to participate in today's webinar, so please, as we go, type in your questions and we'll do the best we can to address as many of those questions as we can throughout our program. So let's get ourselves started. Just a quick preview of what we're going to walk through today. We'll be talking about student free speech rights, staff free speech rights, and how those are analyzed. Some examples of expression that are connected to political speech, things that are appropriate and things that cross lines that shouldn't be crossed. And we're going to try to give you a legal framework to help all of you as you analyze student and staff speech moving forward. So of course, we have to think about the foundation of our student speech discussion. And the US Supreme Court laid out in a critical decision, Tinker versus Des Moines, really how we analyze student speech in a school setting. The Tinker versus Des Moines case involved students who decided that they would like to do a form of silent protest in school. It was a decision that goes back 50 years. So students wanted to protest our involvement in the Vietnam War and decided to do that through silent protest by wearing a black armband on their arm. The school district tried to censor and prohibit that silent form of student speech. This case made its way up to the US Supreme Court, and the US Supreme Court made clear that students do not check their First Amendment rights at the schoolhouse gate. And if students are able to express themselves without creating substantial disruption in the school environment and without crossing other boundary lines that we'll talk about today, students have that right to express themselves in the school setting, even if there might be some disagreements about how they're expressing themselves, as long as they're not causing that substantial disruption. So that was a bedrock decision that has helped guide us as we move forward. We certainly do not want to pre-censor speech that perhaps causes some discomfort, some disagreement. In our society, we have to try to teach our student leaders, our students, as they're working through our system, to have that level of civic engagement, to be able to have these discussions, to be able to disagree and do it in a respectful, appropriate way. And if we were to pre-censor any speech where there was disagreement or some level of controversy, that would really undermine that effort. So the Tinker decision does let us know that if we don't have substantial disruption or interference with the operation of the school or the rights of other students, students generally do have the right to express themselves. There are other limits, of course, when you're thinking about speech in a school setting. And I think those are pretty fairly known throughout our country, but it's important to reiterate a few key points. We cannot have speech that involves threats for obvious reasons. Any sorts of threats of violence are not protected speech. We can't have speech in a school setting that's promoting illegal drugs or other illegal activity. We can't have speech that's lewd or vulgar or explicit, sexually explicit in some way. And we have a growing body of case law in New Jersey and across the country that says if the speech crosses the line into harassment, intimidation, or bullying, that is speech that is also not protected in our school setting. So it's important that we recognize that we're allowed to have a great deal of freedom for our students in speech, but we can't cross these lines.
So, David, can I ask a question?
Of course.
So if a student is wearing a Black Lives Matter shirt, based on Tinker and based on all the cases that came afterwards, that's permissible, correct?
That's right. That is correct.
Okay.
Absolutely.
And if a student is wearing a Confederate flag T-shirt or a T-shirt with the Confederate flag on it, because that's perceived, at least by some, if not most, as hate speech, that's not permissible, correct?
That's exactly right. And we have a growing body of case law. We did include a slide on that that you'll see in a moment. We have a growing body of case law across the country where that Confederate flag has been recognized as a form of hate speech. So
Okay.
once we cross that line, the speech is no longer permitted in the school setting.
Okay. And if I wear a Trump shirt or a MAGA shirt, that too is permissible, correct?
Absolutely. Absolutely. Students absolutely have that right. Now, as we'll see later, it's a very different analysis for staff members, but for students, they absolutely have that right.
Different issue, correct? Okay.
Yeah. We have to think about some recent events too, as we're thinking about these issues. So we all, I think, can recall the horrific Parkland shooting from 2 years ago that sparked nationwide protests involving adults and students. And I think we should be very proud of how well our students express themselves here in New Jersey and across the country in dealing with that issue. In New Jersey, we had many schools where students did have organized forms of protest to address issues of school safety. And school officials worked with those students. They worked with the students to try to make sure the students had safe outlets, had safe ways to express themselves, that they were doing so in a way that was respectful of others, and that they were doing so in a way that school officials were not taking any sort of political stance, for example, on the issue of gun safety. So as we'll talk about a little bit later, it's very different when it comes to staff members and their political expression. But to create a safe space for students to engage in political expression is critical. And we saw this happening certainly after the Parkland shooting. We've seen it again happening. I think we would have seen it much more if it wasn't for the horrific pandemic that we're working through, but we have seen organized student protests in light of the George Floyd killing and other instances of racial injustice that have happened across our country over the last several months. There have been nationwide protests organized to address that racial injustice, and there have been efforts by school officials to make sure that if students are going to express themselves on those issues, they're doing so safely. Of course, that analysis gets much more complicated now as we're working through a pandemic, and we have to think about how to give students safe outlets while social distancing, while wearing a mask, while making sure that we're doing all the other things we have to do in order to keep everyone safe in the school setting. As we think about issues of student freedom of speech, we also have to recognize some of the case law that basically says students have some pretty broad rights to express themselves if they're doing so outside of the school setting on their own time. Even if they might be saying something that is hurtful about the adults in the school setting. So we did have two cases that were decided by the Third Circuit, Pennsylvania cases, but the Third Circuit Court of Appeals does also cover New Jersey. So we had two cases where students pretended to be the high school principal, created phony websites, and pretended that the principal was doing some inappropriate things in each of those cases. Ultimately, the Third Circuit Court of Appeals ruled that the school district did not have the right to impose discipline, in part because the fake websites that were being created were not threatening in any way, did not cross that particular line. All of the speech happened outside of school. Now, I will stress that the individual principals who were the targets of those particular efforts do have rights themselves as individual citizens. To the extent that things are being said about them that cause them real harm, they could individually bring defamation claims. The legal question, though, was whether the school district could impose discipline in those cases, and the court ultimately ruled the school district could not. It would have been a very different analysis if those students had been making those comments in school or at a school event, or had been making those same comments about other students. So let me turn it over to Sandra to talk a little bit about this particular case.
Hi, this case, the Levy case, is a new case. It was decided in the Third Circuit Court of Appeals in June of this year, and it's actually on appeal to the U.S. Supreme Court. They're seeking certiorari to be heard by the Supreme Court. And this one covers a slightly different angle. Tinker talked about an activity in school, whereas Layshock and Blue Mountain talked about things that were geared towards staff members. Here you had a girl who tried out for varsity softball, varsity cheerleading, and only made the JV squad. And she was very upset. So she went home, posted a picture on Snapchat, and put the caption, F school, F softball, F cheer, F everything. This got circulated among her closest 250 friends on her feed, and of course made its way around the school. When the school found out about it, they disciplined her, and she actually even got kicked off of the JV team. She then challenged the discipline, the school upheld it, and now she has filed a lawsuit claiming that her First Amendment rights were violated. That she has the free speech rights to vent and complain if she doesn't like something that happened at the school. And in this case, the Third Circuit found in favor of the student. And what they said was off-campus speech about school, absent a record indicating harassment or threats, was protected. And it cited to Layshock and JS, the Blue Mountain case that David just talked about, where it was saying off-campus speech does have a number of protections. And again, we're talking about students here, not staff. So this actually looks into, particularly now that we're all in this virtual setting, how it's a little bit different when you're in the brick and mortar school or you're at home on your own thing as a student doing what you want to do. And if you are interested, the link down the bottom is the link to the decision itself. So if you want to read everything that it said, it goes through this case, and it also does an analysis of Layshock and Blue Mountain, which David just talked about on the previous slide. Next. So when you're going through this, and we're stressing the assuming it's non-threatening or non-harassing, because this is going to be a big deal to us in New Jersey. We mentioned this is a Pennsylvania case, and because we're in the Third Circuit, we're bound by what they do, even though it's a Pennsylvania case. But New Jersey has slightly different laws dealing with bullying. So what it's saying here is that since it was not harassing or threatening, she's allowed to vent, even if it is vulgar or not nice, or causes a little bit of an uproar in the school. Even if it causes a disruption in the school, if it's not deemed harassing or threatening, she can say it. So this gives her the ability to say what she wants to say off campus. Next slide. This leads to other questions for us in New Jersey to consider. The first being, many of us are virtual now. So if something is said or done on a school-issued electronic device, does it fall into this exception? I would argue no, because technically if you're attending class virtually, you're in school. And there have been a number of instances I've heard about where kids are putting inappropriate things in the chat box. So you want to make sure you save those chat boxes because it's proof in writing of what the kids were saying. You can also ask the question, if you're using a school-issued electronic device, you've handed out the Chromebooks or the iPads or whatever it may be, does that constitute in school? Now, we don't have a case on this yet, but I would argue yes, it could, because it's no different when we were kids back in school, if I wrote obscenities or something bad in a textbook that I had, I'd get in trouble for it. It didn't matter that I did it at night in my bedroom at home. It was still school property that I was defacing. So that's something to be disputed, but it's something to be articulated as we go forward. But I do think there's a likelihood that could prevail. The other issue is maybe someone makes one of these comments outside of school virtually, but then someone brings it into the school and repeats it. The person that brings it into the school, they can probably get in trouble because it's now being repeated within the brick and mortar of the school. You're officially on school property, and it's not something, whether it's a code of conduct violation or a HIB or something like that, it's not something that's supposed to be discussed. Now, David mentioned back on slide 8 about HIB. Remember, there are 2 basic requirements to have a HIB in the state of New Jersey. You have to identify the distinguishing characteristic, to take the legalese out of it, why someone was targeted, and that a substantial disruption occurred, and there are 3 ways to do that. So if you are going to say that whatever was said or done, wherever it was said or done, causes harassment or intimidation, that would satisfy the HIB law in New Jersey, which would nullify a First Amendment right to make such comments, even though they're outside of the school walls, they're not on a school-issued device, they're not during a classroom. So it's very important to take care, and you can't just say this was harassing. You have to be able to say this was harassing because. You can't just use the buzzwords and think that's sufficient. You have to be able to identify what the problem was. Because remember, going back to Tinker, it can't be something that you just don't like or you don't agree with or you find offensive. You have to show how it actually caused a problem. The legalese for that being a substantial disruption. Now, in this case, even though she would have a First Amendment right, as the holdings stand right now, to say what she said, this is still a teachable moment in the age of digital citizenship. Because for any student, they may not realize this. It's hard for them to think 10, 15 years from now because some of them have only been on the earth 10 or 15 years. But if they're going to apply for a scholarship, if they're going to apply for admission to college, if they're going to try to find a job, they're going to get Googled. If they're going for an athletic scholarship, the AD at the college and the coaches are going to Google their name. And then this will come up. So for this young lady, if she plans to try to go for a scholarship, they're going to Google her name and this will pop up. And that may have some bearing on whether or not you get the scholarship or you get into school or you get a job. In this day and age, everyone, you, me, anyone else at this point, if you apply for a new job, you're going to get Googled and they're going to see if they can find something about what you may do that's beyond what you're showing them in an interview. If they come across stuff like this, this could be a reason for them not to hire you or not to give you the scholarship that you're looking for.
That's a
Andrew,
great
may I
point.
ask a question, please?
Sure.
Quick one. Are there any differences whatsoever, no matter how small or large, between using a school-issued or a privately owned device in regards to virtual education?
I would argue yes, because a school-issued device is school property, and the other requirement is that a school-issued device, you would be connected to the school server. So the school has the ability to see anything and everything that's on the server. They don't have to tell you they're there. They don't have to ask permission. It's as if you were in the physical building and they observed you doing it. If they see something you've done on the school server, it's the potential for them to be able to discipline you or tell you, knock it off, stop doing it. Whereas if you're using your own device, when you're coming to, is it within the school walls, I would say that would be a problem. It's a case, I'm sure there'll be a case about this by this time next year. They did it on their own iPad as opposed to using the school issued Chromebook to split the hairs to see what that is. But as of right now, I would err on the side of if it's on a school device, it's free reign because that is school issued property. And most people have to sign one of those disclaimers of, I agree to only use this for educational purposes, one of those types of things. And if you have it in your code of conduct or whatever your agreement is for using these electronic devices, that you will only use it for school reasons or that you will refrain from any harassing behavior or things along those lines, that would also cover the district in being able to handle these types of things and do something about them.
Great question.
Thank you so much.
You're welcome.
If I could
So-
jump in for a second.
Sure.
Yeah, I was going to say something about what's very unique about the Levy case is it's dealing with extracurricular activities. And one of the things that's not settled now or is going to be very unclear, the students who participate in extracurricular activities, these are voluntary activities. The consequences for a coach taking a kid off a team or not placing a kid on a roster is a different type of consequence than excluding a kid from school when we're talking about the Tinker scenario. And it will be curious to see how the case law and how schools evolve with these activities which are above and beyond just being educated within the school building. And as we see more limitations in the school setting for employees, the extracurricular aspect of the school looks more like a setting where an employee has a specific job as an athlete has a specific responsibility to a team. That's not clear as a result of this case, and how extracurricular activity and speech may have some boundaries at this point.
I'll take it one step further, though, particularly in the special ed realm. There are many times where in the IEP or part of their learning, the student gets something beneficial from being on a sports team or in the drama club or whatever it is that they're doing. And so that being on this team is part of their free and appropriate public education to get them what they need to do to get their appropriate education. So it can all tie back. And there are other issues. I mean, there are some kids that they only come to school because they want to play sports. Yeah, they do the
Sure.
schoolwork because they have to maintain the GPA. But if you take away sports from them, their GPA goes out the window. So I think there's a closer tie because all of these activities are considered part of being in the sport and in the district community. So I could see that being a link in there.
So let me move us on to the Sibnewski case, which I think is a very important case for us as well. It was a New Jersey case, and here we had a high school student who wore a Jeff Foxworthy t-shirt that said, "You might be a redneck if," and there were lots of examples of what might make you a redneck on this particular t-shirt, including a reference to the Bud Bowl at one point. At the end of the school day, when the student was wearing the shirt, the student was asked to remove or turn the shirt inside out. It was deemed to be a violation of both the district's racial harassment policy and dress code policy due to the comments on the shirt. The student refused and was suspended. Next day, the student's younger brother wears the same shirt to his school in the district, and there were no issues. He was never asked to remove his shirt or turn it inside out or change the shirt. Both students wore the shirt to school on several occasions prior to the incident and had never been asked to remove it. This student in this one particular case was told to remove it and was subjected to discipline. So what happened? The family sued the school district and alleged a violation of the high school student's First Amendment rights. Now, I do want to point out that when you look at the case in further detail, the district did have a history of some racial tensions. There had been what were called White Power Wednesdays that had been held in this particular community. There was a gang that was called the Hicks that had been bringing the Confederate flag into school and engaging in some forms of inappropriate speech with racial undertones to it. So the district was extremely sensitive to those issues. However, the students and their family were successful in challenging this on First Amendment grounds. And I think there's a few important lessons to come out of this case. First, we had both students wearing the shirt multiple times, and there was no evidence of actual disruption in the school environment linked to wearing the shirt. You also had a district that was inconsistent in applying their dress code policy. If this really had been an issue, it should have been noticed each time a student was wearing the shirt, and we had multiple occasions where the issue was not raised. And the district was unable to connect the shirt to the gang that was called the Hicks. They had some theory that maybe the two were connected, but there was no actual evidence to back that up. And there was no specific evidence saying that the use of the word redneck was in some way a form of hate speech or some sort of a code for hate speech in the school district. So there were theories that the district had, but you need to be able to have some concrete evidence to back those theories up if you're going to censor speech. Courts do not want to censor speech, and you're going to have some tangible evidence for that to actually occur. In this particular case, one of the important lessons is that it can be very expensive to get this wrong. It ended up costing the district about $600,000 almost all of it to pay for the legal fees of the family that it sued. So in a case like this, you want to make sure you're going to be consistent. If you have some theory that a shirt is connected to hate speech, you need something more than that theory. You need some evidence to back that up. And you need to make sure that you're following through each time you see an issue like this, not sporadically in one case versus another. So it was a good cautionary tale. I do want to say that
It's for those administrators who are listening to this right now, it's a cautionary tale on what not to do.
yes,
If you're an administrator in a school district, you should discuss the action that you're contemplating before you take it. You shouldn't react. You shouldn't react precipitously. I think in Wisniewski, that's exactly what they did. Sibniewski, that's exactly what they did. They acted precipitously and they didn't think. I mean, the fact of the matter is that the student who was suspended was only suspended after he wore the shirt all day, and the administrator saw at the end of the day that he was wearing the shirt. If it was a problem, it would have come up before the end of the day, and that his brother wore the same shirt and it wasn't a problem, should have told the administrators to be super careful about what they did here.
absolutely. So we have had cases throughout the country in recent years, a growing number of cases that have made clear that schools are within their rights to say to students, you're not allowed to bring the Confederate flag into school, whether it's actually a flag or it's a flag on clothing, because of the historical associations between the Confederate flag and slavery and racism. So there is a growing body of case law along those lines, and I think we are seeing some new forms of student expression that we'll talk about later, where students are involved in virtual instruction, and perhaps you can see something like a Confederate flag in the student's background. And the home has arguably become an extension of the school at that point in time. And I think schools will be able to limit the expression even in periods of virtual instruction. So we've seen a growing number of cases that say the Confederate flag would cross that line into hate speech. Sandra?
Yes, I have a couple of examples here of things that have happened. And I will tell you, every time I do a presentation on social media or First Amendment rights, I go in and I Google violations on the internet by students or staff, and I always find new material, unfortunately. So feel free to turnkey this stuff and bring it back and use them as examples. So in this particular case, this was just June of this year. In Paramus, students posted on social media, they were having a text chat. Someone saved it and then posted it. And this is a good example to use with students of anything you put on the electronic device, text, whatever it is, can be made public. You should assume someone's going to see it. So be careful of what you put out there. So this group text message had prejudicial remarks about Black people, women, people in the LGBTQ community, including comments referring to Black protesters as monkeys, comparing Black families to cockroaches, and mocking George Floyd's "I can't breathe" statement. This got reported to the police, as all of these things are based on protected classes. Your race, your gender, your LGBTQ status in New Jersey, those are all protected classes protected by discrimination laws. As well as under the memorandum of agreement, there's an obligation of the district to report to the local law enforcement that this incident happened. So the messages got reported to the police, and the police are now involved in looking into what these kids did and whether or not this will become something that they have to get involved with. And I will say, for all of those examples, there are links to the articles. So if you want to read the article in full, and for some of them see the videos, they're there. So use them to turnkey as a message. This was another one. This was from about a year or so ago, where these young boys were at a prom, and they all were having their picture taken, as you can see. And it looks like that they're giving the Heil Hitler sign. This picture got circulated around. Now, a number of them were saying, no, we were just waving to the camera. But in actuality, a number of people did not believe that. And this created a huge uproar when this got put around, and that a number of kids lost college scholarships. The schools were calling in and saying, unless you discipline these kids or don't admit these kids, we're not going to give you contributions. We're not going to contribute as alumni to the school. So use these as examples to your students about how there are long-term effects for stuff that ends up going out on the internet. It does not disappear. It doesn't just go away. This was another one down in McRae, Georgia, where these kids were on a bus. They were coming back and they were taking pictures of themselves with white bags over their heads, pretending that they were white hoods worn by Ku Klux Klan members, and that the pictures were taken after the kids on the bus had just lost a state tournament to another Georgia school that had several black players, and they ended up being investigated and disciplined. This stuff is not joking around. You can't just say, oh, we were fooling around. Put aside the heinous nature of what the content of this is. Students and not just the students, adults don't understand that you can't just fool around and post it online because everything gets seen. As a prime example of that, we have this from last November where an 18-year-old put on Instagram that I need a guy who could kill someone. No joke, I need him eliminated as soon as possible. We have $100,000 for the victim's head. And he was talking about an employee at the school district. The messages got reported to the school resource officer who turned it over to the police. They were able to trace the IP address from where these came and then narrowed it down to this kid's computer in the house. And he was charged with attempting to conspiring to commit murder. And his defense was, oh, come on, I was fooling around. Can't you guys take a joke? I didn't really mean it. And the police statement quoted here, it doesn't matter if someone says I was joking. It doesn't matter what their intent is. When you do it and you post it out there on social media, you committed that crime. And again, I've given you the link to that article. This is actually the statute in New Jersey that backs up that the police can be involved with things that are posted and that are out there because they could be deemed terroristic threats. So if someone puts out there thinking they're funny, oh, I'm going to bring a gun to school tomorrow, or it'd be good if they blew up this, or something along those lines, that's going to get reported to the police and they're going to come knocking on your door. And it could be seen as a crime. You could get convicted of a crime, which carries a third-degree felony and 3 to 5 years in a New Jersey state prison upon conviction. Even if you don't end up getting the felony conviction, you may get something on a rap sheet or on your record that's going to follow you the rest of your life. So you could do something at 17 thinking you're being funny, and this could stop you from getting a job when you're 42. You have to try to get this through to the kids so that they understand that.
So this is a summary of student First Amendment rights. Of course, students have a right to express themselves on political issues as long as the speech doesn't result in substantial disruption, as long as it's not interfering with the rights of others. HIB, harassment, intimidation, and bullying, of course, is not protected speech. Student speech outside of school sometimes is still protected, even if it's critical of staff members, as long as it's not crossing that line into threatening speech. Student protests regarding issues of racial justice or any other issue of current events, we have to be aware, could create a conflict between student expression and maintaining public health requirements. So we want to work with student leaders and find safe ways for students to have those opportunities to express themselves on these critical issues of the day. So it's very important that we engage with students. We don't want to simply say, do not express yourself, do not deal with this issue, it's too controversial, it's too difficult to figure out how to do it safely. We want to engage with students and help them find responsible, appropriate ways to allow for that expression. So as we transition into staff speech, it's a very different analysis. We have a case called Pickering, where the court laid out a 3-part test when we're considering whether a staff member's speech is protected or not. So the first part of the test is whether or not the statement that the staff member makes concerns a matter of general public concern. If you're talking about political issues, you're talking about policy issues, social issues of the day, that level of speech gets greater protection, as opposed to if you're just complaining about a colleague or airing a personal grievance towards somebody else. Much greater protection when you're talking about matters of general public concern. You also have to ask if the staff member is speaking as a private citizen, or are they speaking during the course of their duties? Are they expressing themselves as if they're speaking on behalf of the school district? You have much broader leeway if you're speaking on your own time outside of work as a private citizen, as opposed to representing that what you're saying is on behalf of your school or your district. And the third part of the test that our courts have laid out is whether the statement is likely to disrupt a close working relationship. So if you say things that are, racial in nature, for example, and undermine your ability to work with students, with parents, with your colleagues, that statement could be so toxic that even though you might have been talking about a matter of public concern, even though you might have been speaking on your own time, it could still make it impossible for you to continue to work in that school district because you've so undermined those close working relationships you have to have in the school setting. So that's the three-part test we want to think about when it comes to staff speech. And the court in that case did expound a little bit further to try to help analyze those issues. So for example, is the employee who might be a teacher talking about daily duties in the classroom? Are they talking about the regular operation of the schools? Are they talking about the working relationship they have with any particular person at the school? And that all factors in to the level of protection we're going to give that speech. And teachers and other staff members in the school, can't simply be reckless with the truth and put out information that is going to undermine the ability of that school district to operate. They can't simply be speaking just to create havoc, to create disharmony in the school. You can't be speaking in a matter that's just meant to undermine your boss or undermine your supervisor. You're not going to have the same First Amendment protection if that's your agenda and that's your goal. Or if you're compromising loyalties and compromising confidences, perhaps sharing confidential information that should not be shared, that's not going to be protected under the First Amendment. You also have to keep in mind the U.S. Supreme Court has made this clear that if you are working during the day in your official capacity, you do not have the same First Amendment protections. And our courts have said that on a number of cases, and we'll talk about one of those cases in a moment. So with that, let me turn it over to Sandra to go a little further.
I will say too, taking off on Pickering, what I generally tell people as a staff member, if you only know about it because you work for the district, you can't talk about it with anyone outside of the district. You're privy to a lot of personal private information about students and staff, depending on what your position is. So you can't talk about it with your friends, with your neighbors. If you live in the town where you work and you're sitting at your kid's softball game or soccer game, you can't talk about what's going on with the staff at school. This would also apply to if you don't like how your school is handling COVID issues. You don't vent about it publicly. Now, I'm not saying you can't complain. You complain internally. You go through the proper channels. You go to your union rep. You go to your supervisor. You go through those processes and possibly even legal issues if it's an OSHA matter. But you're not supposed to put on Facebook, my school superintendent's an idiot for opening the school or not, or keeping us home, or whatever your personal opinion may be. The other thing to point out in dealing with this is that anything and everything a staff member does can be seen on social media by anyone. You have to realize you're putting it out to the World Wide Web. Now, an employer cannot request your private personal passwords. This was a problem when the internet was first really starting to take off and people had the MySpace and the Facebook accounts and such, where people would say, give me the password to your Facebook account so I can see what you post on your personal account. You can't do that. The employer is forbidden by law from doing that. That's what the PL 2013 C-155 is. However, you should assume, as a rule of thumb, your worst enemy is going to see whatever you put up there. I will tell you, I talk about free speech rights a lot. I do not have a personal Facebook account, but my dog does. And with my dog having an account, I've gone in and looked up people I went to school with 25 years ago just to see what I could find. And I had full access to their entire account. So if your district has a Facebook account and you're searching someone who may be a potential employee, or you want to see if they've said something because you have a tip-off that they're putting racist comments or politically incorrect statements or whatever the issue may be, you go in under your district Facebook page and just pull up their name and look, and you can see everything. And you have to be careful because you may have set your privacy settings, but anyone that you friended, they may comment or they may share or they may link or like what you posted. It's now on their Facebook page. And if they don't have the same privacy settings that you do, it's fair game for anyone to be able to see. These are two cases to compare and contrast. The first one is the Petrillo case. This is going back to MySpace, so it's showing you how old it is. bunch of kids in a pizza parlor didn't like their boss. So they created a MySpace page to vent about it. Boss found out about it, forced one of the kids to let her in and see it, and then promptly fired everyone involved. The kids sued, claiming it was a violation of their privacy rights, and they won, because in this case, the employer had forced her way in. It wasn't something where she could just see by just doing a random search. She had to have someone let her in to see it, and she wasn't allowed to do that. Contrast that to the Ellen case. This was a woman who worked for a company. She had friended many of the people that she worked with. She was putting some politically incorrect things up there, and she was saying things that were disparaging towards the company. People that she worked with screenshotted it and then sent it to the boss. And the boss then disciplined her for what she had posted on her private personal Facebook page on her own time, on her own server, you know, on a weekend in her sweatpants on the couch kind of thing. And she said, wait a minute, you can't do that. This is my private page. And ultimately the employer prevailed, because in this case, they had not snuck in. They didn't do anything surreptitiously. They hadn't snuck around. They were provided with the information. To put this into a school setting, if a parent or someone sends you a screenshot of something they saw posted online, the school gets to act on it. Actually, they have an obligation to act on it and follow up. Doesn't necessarily mean there'll be discipline coming from it, but it does mean they have to ask the staff member about it. One of the other problems comes when you have staff that forget that they cannot be friends with their students. They can be mentors, they can be role models, but they're not supposed to be friends. There's actually a law came out in 2014 that says district employees cannot be friends with their students. This is because you don't want to have a private relationship between a student and a staff member. Everything that the staff member does in relation to the student and even communications with their family pertaining to their school should be done on the school server. The school has an obligation to be able to see everything that's there. And the rule of thumb is if you're going to post something or send an email or send something and you have the feeling, I don't want my supervisor to see this, it's inappropriate. I don't even need to know what your content is. If you don't want your boss to see it and you as a district member or a district employee are communicating with a student, it's inappropriate. It's the wrong thing to have there. So this was the O'Brien case. It came from a number of years ago, but what happened was this was a first grade elementary teacher. She was working at the school. They had had a Scared Straight program, and then on her private personal Facebook page, she posted the comments, I'm not a teacher, I'm a warden to future criminals. They had a Scared Straight program in my school. Why couldn't I bring my first graders? People found out about this. Somehow someone saw this, brought it to the school's attention. There was a huge uproar about it. The media got involved. Parents were protesting. They were getting tons of phone calls, and there was a big uproar about it. They filed charges against her. She was unapologetic. She had the feeling of, well, I didn't mean to hurt anyone's feelings. What's your problem here? You know, I wasn't aiming it at anyone in particular. And she claimed a First Amendment right to be able to say what she wanted to say. And she lost. She ended up being dismissed. And she appealed in the New Jersey courts, and the New Jersey courts upheld her dismissal, saying, and they cited to Pickering, the case that David mentioned early on, that you don't have carte blanche to say whatever you want, that this had caused a real problem in the school, and that quite frankly, her claim of having it was a racial justice type of thing, the court said a private personal Facebook page commenting about your students is not the place to have a racial justice conversation about what's happening in your school. The place to do that is in your school and going through the proper channels. So the court upheld her being fired. This was another case where this was in the classroom, where the teacher was teaching about an essay called 6 to 8 Black Men. Apparently in the Netherlands, there's a tradition that Santa Claus has a black man that follows him around and goes with him. And so she was talking about this, and she wanted to prove that this was still happening. So she showed pictures of her white relatives who lived there in blackface, acting out the elf with the Santa Claus. There was a black student in the class who was very upset and offended by this, went and complained. They filed a HIB claim against the teacher. So looking at from the HIB analysis, the distinguishing characteristic would be race. The substantial disruption was he was embarrassed, he was upset, didn't think he would get a fair shake in the classroom. He ultimately confirmed that it was a HIB, and they gave her a written reprimand about it. She filed a grievance. Ultimately, because of what happened with the grievance, the discipline of the letter of reprimand got pulled, but she wasn't happy with that, and she actually filed a lawsuit against the district, claiming that her First Amendment free speech rights and her 14th Amendment rights were violated. The 14th Amendment would be that you can't put me, teacher, through this HIB process. And the court threw the case out. In the First Amendment issue, they again cited to Pickering. And the highlights from that are the courts have found that in-classroom speech made by an educator pursuant as part of a curriculum is not speech on a matter of public concern. Remember, all of you that are supervisors, you have to approve the lesson plans. You have to approve what's being taught. And the district is legally responsible for anything and everything an employee says to a student. So if the employee does something wrong, the district's going to be on the hook for it. The teacher's classroom was a private forum engaged in the exclusive purpose of educating her students. Public school classrooms during school hours are typically regarded as non-public forums. And then the 14th Amendment was saying the school had properly applied the HIB process, and yes, the school can apply a HIB process to a staff member. This is a very recent one, happened last month. A teacher wore various face masks to school that said Black Lives Matter and silences violence. The administration had asked her, please wear a generic mask. We don't allow masks with any political slogans. Politics is not the place on your mask to talk about it. We will deal with it as a school where we should be dealing with it as appropriate. And she refused to stop wearing the mask, and so they fired her. Now, I don't know if she had other disciplinary measures in her history of being insubordinate and not doing what she was told to do or not following the rules. But it is something that could happen. I mean, even for a non-tenured staff, something like this could be a basis for not being granted tenure. So yeah, you have to be very careful. This happened back in April when the pandemic was really starting to kick into high gear. There was a teacher that was out walking her dog, and she came across a number of kids that were playing basketball in a park. And so she said to them, and the kids were videoing her, if you click on this link, you can actually see the recording of this. Park closed the whole area, get it through your thick head. You are the reason we are in this situation. You are the problem, not the solution. Go ahead, keep recording. Who are you going to show it to? Post me on social media. You're the idiot doing the wrong thing. I'm just trying to save your blank and save your life. But die, okay? I hope you both get the coronavirus. I hope you both die a long, painful death. This is the teacher saying this to student-age kids. If this is the teacher in your district, this is definitely a basis of a HIB claim, a potential HIB claim. You'd have to do the analysis of were the kids bothered by it. If they weren't bothered by it, it wouldn't be a HIB claim because you wouldn't have your substantial disruption. But you would certainly have a display of lack of professionalism and inappropriate behavior. She does not have the First Amendment right to vent like that when she's out in public. This was from a couple years ago. It was a superintendent was watching the Texans play, was very unhappy, and he posted on his private personal Facebook page, football fans can't count on a black quarterback. And the comments were made in regard to the Texas quarterback, Deshaun Watson. His defense to this is that he thought this was a private communication from friends. He didn't mean to post it publicly. That's not a real defense. That doesn't work. It's just as bad if you would send it privately as if you would post it publicly. This went public though, and several days later, he ended up resigning because of it.
So of course, we're seeing so many of these examples, and there are lots of examples that are specifically connected to political speech. I think, Sandra, what I'll do is just run through these very quickly to make sure we keep ourselves on schedule. Just to stress, neither party has a monopoly on improper speech, certainly related to presidential elections. We've seen it coming from both sides of the aisle. We want to make sure that we don't, as the staff members in schools, react differently depending on our own political ideology. We can't start favoring certain political views versus others. And we always want to keep in mind the substantial disruption standard when it comes to speech. So just to walk through a few quick examples, we did have a case where a California high school teacher compared President Trump to Hitler. Another case where the teacher was disciplined for anti-Trump tweets and remarks about students. A college professor made anti-Trump Pence comments and stated the election was an act of terrorism during a lecture. I will say this, our courts have looked differently at the rights of college professors versus teachers K through 12. So there is some additional leeway at the college level that you do not see as far as your right to express your political views in the K through 12 setting. We also see a number of student speech examples that are very concerning. Students chanting "build the wall," and we've seen that happen in a number of cases. Now, someone might argue, well, students are expressing a political view, but when a very large number of students start chanting something like this, frankly, it becomes kind of an intimidating, threatening form of speech. And now we're crossing that line into harassment, intimidation, and bullying speech, most likely, that does not have that same First Amendment protection, even if arguably there's a political element to the speech. We saw a case of a 7-year-old kicked out of his home by his mother because the 7-year-old admitted to his mother that he voted for Trump in the school's mock election. It was actually caught on video. We have seen lots of student walkouts due to election results. Student walkouts for other reasons that I mentioned earlier as well. When that happens, as a First Amendment right, students frankly do not have the right to get up and walk out as a form of protest. That would cause substantial disruption to the school environment. The school administration could say no to it. But what we saw with Parkland was an effort by school administration to work with student leaders, to engage with student leaders, and to provide a safe means for students to be able to express themselves. And I think that was a really valuable lesson on how we can make this a real teachable moment. We saw here a quiz that referred to the president as an idiot. So we've seen staff members using their work assignments or class assignments to, in a not so subtle way, express their political views. We've seen staff members sometimes go even further, as you can see in this particular comment that was posted online. Obviously, now we're seeing threatening speech, even beyond just political expression. Sandra, do you want to talk about this one for a moment?
Sure. This was back again with the last election where it was a pro-Trump teacher and a pro-Clinton student. And this was right after the Access Hollywood tapes had come out about President Trump. And so the student was talking about how not nice President Trump was. And so the teacher said, well, do you know about Monica Lewinsky and that, Mrs. Clinton is a racist and things along those lines, and went into detail about those issues. And then the student went home and said, hey, Mom, guess what I learned in school today? Mom was not very happy and actually called the local reporter about it. She skipped going to the administration, went straight to the press. And actually, if you click on that link there, you will get the clip that's always shown when a district is the subject of being accused of doing something wrong, of the reporter out in front of the sign in front of the school talking about how staff is influencing their students and things along those lines.
And I should have said as a housekeeping matter at the beginning, everyone who is registered for this webinar will receive in about 24 hours the recording of this webinar and the PowerPoint that goes with it, with all of the links. Here we had anti-military comments in the classroom, California teacher making negative comments regarding those who decide to sign up for the military. And again, those are political comments that are really not appropriate for a teacher in the classroom. Here we had a group of teachers who decided for Halloween 2 years ago that they would come to a school function dressed as the Wall. Obviously here they're in a not so subtle way expressing political view, and that is inappropriate for the school setting. This was an Idaho case. Certainly in New Jersey, those teachers would be subjected to discipline, and there would be no First Amendment protection anywhere in the country for that sort of speech. We see other creative forms of speech that are inappropriate and crossing lines. Here, as part of a Cinco de Mayo celebration, we had a group of students who were told, well, here, you can smash this piñata. And not a great image, but I think you can make out the piñata had a picture of our president on it that students were smashing. So not such a subtle political message. We see this in a particular assignment, a not so subtle political message with students filling in the blanks regarding President Trump and President Obama. Very different focus to what they were asked to do, depending on the particular president that they were talking about. A couple links here to what we're starting to see over the last 6 or 7 months. We had a case where a New Jersey student says he was disciplined for having a Trump banner visible during virtual instruction. Here it's Trump. Obviously, the same sort of issue could happen if someone had a Joe Biden banner or another political banner. So students, again, have a right, if they're engaged in forms of silent expression, to express themselves even during the school day. They don't have a right to disrupt the school environment or disrupt virtual instruction, but this would certainly be within a student's rights to have a visible banner while they're involved in virtual instruction. On the other hand, we see a case where there was a fourth grader in Louisiana suspended for having a BB gun visible during virtual instruction. Arguably, I think it would be appropriate for a school to place reasonable limits on any sorts of weapons that are visible to other students and the teacher during periods of virtual instruction. Now, this is, has to be balanced against the fact that you're going into somebody's home and seeing their home. But I suspect a court would balance that and say it's not appropriate to be able to see that sort of weaponry when you're involved in periods of virtual instruction. And it's not so invasive to make sure that the student's camera doesn't allow that sort of thing to be seen. But I will say you want to be very clear in your district code of conduct when it comes to that issue. So before we transition, Andrew, any particular questions coming up in the for folks involved here?
David, there was one question that one of the panelists, Mark, raised. I think you spoke about it, but maybe you can elaborate. He wanted to know if how districts with racial unrest or protest should be considering the student expression that's relevant to that issue, and he wanted some discussion on the balancing with the added relevance of the speech along with the risk of disruption.
So you certainly want to make sure that students have a right to express themselves even on difficult, controversial issues, if they can do so in a way that's not causing disruption in class. So it takes a lot of preparation. It takes a lot of advanced work to sort of lay out the ground rules. If you're a social studies teacher and you're going to have a discussion about current events and racial justice issues, you want to lay the ground rules in advance to allow for that respectful discussion and make clear what's not going to be appropriate. Once you do that and lay those parameters, you want to make sure you enforce them even-handedly and you provide a safe space for students to express views that could be opposing, as long as they're not engaging in threatening speech, hate speech, demeaning speech, ostracizing others. So setting the ground rules is a crucial part of that process. I think we'll leave the rest of that. I think this will be a great discussion for us to have in part 2 with our panelists.
One other thing I just wanted to add. It was pertinent to the discussion that Sandra was having before with the examples from the recent history of both staff and student speech that was contested. I think one of the panelists, Mike Vanella, sent an email earlier yesterday about an incident that happened in the Toms River School District where a student was asked to remove himself from a virtual learning session because he had a Trump for president sign in the back of his room. And the student, after he was removed, was ultimately not disciplined. And I think the principal is on the record in the article saying that the teacher was in fact wrong to remove the student from the class. And I was just, I throw that example out there because it was in the papers recently. It is timely to the issues we're facing today and to this discussion. And I think it could have been handled differently in a number of ways, some better, some worse. And I think it's sort of a discussion that maybe we can have in part 2.
Absolutely. It's a great example. And we did, by the way, have a brief reference to it in one of the slides. So you can have a link to the article that Andrew's talking about. So with that, I wanted to just transition us at this point to our panel discussion. I'd like to kind of turn this over to Mike Vanilla, Mark Mondry, and Michael Solosky to introduce our students one more time and get our panel discussion started. Mike Vanilla, you want to get us started?
Thanks, Dave. And that was a great opening session. We really appreciate it. What what a wealth of knowledge, and the members of NJPSA are fortunate to have the legal team that is down there. But as you said, it's now time to turn it over to listen to our students. And I think I want to thank NJPSA for hosting this, but also recognizing the importance of student voice. And I'm glad to see that part of this, the second half of this, is going to really focus on listening to our students, because that's why we're here every day, for our students. So at this point in time, I'd like to just reintroduce everybody, starting with the group from East Brunswick, and maybe Mr. Mondry, who was our AP IPL instructor. Mark, would you want to introduce our students?
Sure, thanks, Mike. I agree. I'm very excited to hear from the students. I'm going to try to keep myself out of this as much as possible. I've got a ton of things to say. As David and Sandra were talking, I just kept wanting to ask more questions and jump in. But I agree with you. I think the most inspiring things that are going to be said by the students. And I brought two of them with me today. Again, this is Minta Sona and Jonathan Roy Varghese. They are two of my seniors in that AP program, and they'll be competing in the We the People competition later this year. That's sponsored by the Center for Civic Education.
Thanks, Mark.
Mike, go ahead.
Also, we have with us Mike Solowski from Rawway, who also has brought a couple students. Mike, do you want to introduce your students?
Sure. First, I'd like to say what a wonderful presentation, especially in the day and age that we live in today, with an election taking place in a matter of mere weeks, civil unrest going around the world, and things happening in schools that certainly weren't taking place even when I was younger, about 20 years ago when I was in school. But I have two wonderful students, Jalissa Muller and Scott Nwosu, who are four-year members of Rawway High School's Student Government Association, and they are leaders in the organization. And I can't wait to hear from those two and from Minta and Jonathan regarding their experiences at school and outside of school, and their views and possible questions and their opinions. So I can't wait for this part. This is just wonderful.
Thanks, Michael. And so Minta, Jonathan, Jalissa, and Scott, it's now for the adults to kind of take a backseat and listen to you. We came up with a handful of questions that we think that are relevant to the times. So I want to just get started right to it. Our first opening question, what do you believe are the limits on student expression during time, place, and manner? And why don't we start with talking about that, putting that in the context of the classroom or the hallway? Talk to me about that. What are your thoughts?
I think in general, I would agree with the Tinker kind of argument in that if anything causes a substantial disruption to me being able to learn, that's where I would draw the line. And I think there is a distinction between the hallway and the classroom, particularly because if somebody isn't in my class and I see someone wearing or saying something that I don't necessarily think belongs in the hallway, that would cause me at most to be late to my class, but in class that might stop me from being able to learn. And so I think there's a distinction to be drawn there, but I think overall it comes down to whether or not it inhibits me from being able to learn in my class.
Yeah, just to go on with that, I also think that the hallways certainly have a lot less limits, in that also one where it's not really where a lot of the learning happens, but also at least in like my school, it's a lot harder to manage what's like going on in the hallway. There's like a lot of students moving between classes, and like at times I've like heard a lot of like obscene language, and obviously there's like shouldn't be encouraged, but it's also not necessarily going to like take away from me learning about something, whereas if it was in a classroom, then it might have a bigger impact.
I absolutely agree with both of them that student expression should be it shouldn't be as restricted in the hallways rather than the classrooms, because as soon as you enter the classroom, our main focus is to be learning, not to interrupt any of the stuff like that. But when it comes to student expression, I feel like when it comes to the interruption of the classrooms or distractions, I feel like it's not up to the person who is wearing or who is expressing themselves. It's the people who are responding to it that is the main problem.
I also agree that students should be able to fully express themselves based on their appearance. my own limitations. So long as it was just a few individuals who feel disrupted by a shirt, then I'm not sure that necessarily counts as a disruption for the whole class. Now, if the whole class got disrupted from what a student may be expressing, then that would become an issue. If it was just for a few individuals, then that shouldn't be too much of a concern on the student behalf.
Has there been any experience from the classroom that you could think of that the limit of student expression might have come up or didn't come up and you thought that it should have?
There was a time where students have sometimes worn T-shirts that have very strong political views in class, but I didn't find that that necessarily inhibited my ability to focus on the class. But I know that there were people who did feel strongly about the T-shirt that they wore, especially some of my friends who went to my class with me. So I'm not exactly sure if that should have warranted action against that person, or if that was just them exercising their First Amendment right to wear what they want, especially with like the Sibniewski case, where he was allowed to wear the T-shirt that he wanted to wear. So that was my experience.
Yeah, I can also think of a very similar situation where I remember in a gym class a few years ago, a kid was wearing a shirt that had like some vulgar language on it, but it wasn't immediately clear when you were looking at it because the language is more like shaped in sort of a picture. But a few of my fellow classmates like noticed this, and then for like the rest of the period throughout the class, people were talking about the shirt and sort of like almost laughing that like none of the teachers were recognizing it. And then this person went on to wear the shirt several times throughout the year, and each time it took away a little bit from what we were talking. So I think maybe in that case, the limit should have been addressed.
And of course, our courts have made clear that if you're talking about vulgar speech, there is no First Amendment protection for that.
I had a question to ask really quickly, if I may. One of the things that I wanted to ask about was if Sibniewski was happening in today's age and somebody were to wear a T-shirt to school that had a very strong message, and if somebody else were to potentially feel offended and fight them or exchange physicalities with them, would there be a case for Sibniewski or for the person who wore the shirt to say that they were just exercising their First Amendment right and somebody else took offense, or would they be punished also for having caused a fight within the classroom?
So as a legal matter, I'll jump in quickly. You really shouldn't have what's called a heckler's veto, where somebody who decides to instigate a physical confrontation is allowed to, force the other person to censor their speech. So in the scenario you're describing, I think the issue would probably be the student who's instigating the physical confrontation, because we didn't have anything on that T-shirt in Sibniewski that would be considered hate speech or crossing those particular lines. And it would be the other student who started the physical confrontation who I would think should be addressed.
Thank you.
Let me make the transition. What about on the athletic field? Do you think there's limits on student expression once we get outside the classroom and onto the athletic field?
Well, speaking personally as an athlete myself, because I'm a part of cross country team for 4 years, so I think there should be a limitation because you're still a representative of the school. So your actions do affect how you appear to yourself and how you appear to your teammates, along with your entire school and its district itself. So I believe student expression should also be enforced on the athletic field as well.
I completely agree with Scott, where even if you're not technically in school, you are still representing the school as a student, and even the staff members, like you really shouldn't, you should still be abiding by the rules of the school, even off the field when you're still representing your high school.
I also think that the fact that you're addressing a much bigger audience when you're playing, but you have the fans, your family, your friends. I think the fact that you have a much bigger audience than you would in a classroom or in a hallway also has something to add to that idea of your message being much more pronounced and much more viewed by other people. So I think that also has to weigh into how much reprimand or discipline might go into something that might be vulgar or hate speech.
So
Yeah.
let me jump in here and get specific. Mint, I'm going to pose a question to you because I know you play basketball. How would you feel if Coach Lane said, that none of the athletes were allowed to take a knee before the game, expressing like their sort of belief in racial justice. What would your reaction and what would your teammates' reaction be if that was the decision of the coach?
Well, I think that a lot of us would be kind of, I guess, put off by that. I think that a lot of us would share the view that simply kneeling is not necessarily enough that is like disruptive, and if anything, in some cases it could be sports is not necessarily always the right place to discuss politics, and we've seen this discussion on a greater level, not necessarily in schools. But in this case, I think that the freedom has a lot of weight in the political speech, and simply kneeling, I don't think is enough that it would disrupt from the main event of playing basketball.
So let me transition here. We'll talk about those playing. Let's transition to those in the stands, whether in the stands in the auditorium, at a sporting event, or any school-sponsored event. I know, for example, here we have a great following at East Brunswick High School, the Bear Den. What are the limitations of expression for a student that is in the stands at one of these events? Do you believe there are limits to them?
I think on Minta's point, kind of the same thing where if a student says something or shows something that fundamentally takes away from the game that's happening in front of the audience, I think there should be a limit on that, particularly if it's something that could be interpreted, as offensive or at least as something that shouldn't be allowed in a school classroom setting in front of an audience that's trying to watch a game.
Yeah, I
Meant
can.
to raise the point, just to jump in, that if you are taking a knee before a game, it's not going to really disrupt the game and it's not going to really interfere the game. But what if it does cause a stir in the audience? Should it be analyzed any differently?
Well, I think that in a specific case where one of my teammates or myself chose to kneel, then if there was a disruption, that I guess the immediate reaction in that moment would be obviously to refrain from doing that action, as to try and avoid that. But as like a long-term administrative point, I think that if this is like a common thing where kneeling possibly does create more of a disruption and possibly affects the game, then maybe there should be some possible restrictions or something. But I'm unsure if that would have to be balanced with the political weight of the kneeling.
And I think a court would be very reluctant to censor the student's ability to kneel because somebody in the stands was offended by that. It's kind of a classic example of a speech that's sort of inherently not disrupting the game, not delaying anything. So I think a court would be predisposed to want to protect that speech.
Right. Perhaps if a scenario like that happened, or if the school knew it was likely to happen, they could have security escort certain people from the audience out.
Mm-hmm.
So if I could just keep us going in transition, because we all found us with the recent pandemic in a unique situation of virtual instruction taking place, and maybe not necessarily in a classroom, but behind a screen from home, but still participating in classes. So I would like you, and we just heard about a case earlier, just that came to the news yesterday from Tom's River, virtual instruction. Minta, Jonathan, Jaleesa, Scott, what do you believe are the limits on student expression when it comes time to you participating in virtual instruction?
I would say that I'm split on this in a sense, mainly because I understand that what you show in your room, particularly if you have your camera on during class, is visible to other students and then hence can be a distraction. But also the idea of what is in my room is technically in my room and I own that property and I have a right to keep my room the way I want it. And so I think in general, I would go to apply the ideology that if what you're showing does fundamentally take away from the classroom, then you might have to take it down, because with the new virtual era, what is visible in your camera is technically also in a classroom setting. And so with that ideology, anything that is in there that could take it from the classroom would have to be removed, even though it's technically your room. That's where I would stand with this.
This question is definitely more difficult, but I feel like if the whatever is in the room during the class, as long as it's not actively causing any kind of distraction, or it's not clearly threatening or harassing anybody, then I feel like they should be able to put whatever they want. Like, you know what I mean?
So they can there can be any poster on the wall that they so choose, as long as it's not a distraction.
Yes, as long as it's not an active distraction and as long as it's not clearly harassing or threatening or causing some kind of danger.
So I'll jump in here. As a teacher, my instinct when I read about the case in Tom's River was I would probably have asked that student to put up a virtual background to avoid even the risk of disruption. Now, I'm not sure a court would necessarily agree with me, but I'm interested to hear like how the students would react to a teacher asking them to do that. Like, is there a difference between being asked to put up a virtual background versus being asked to take down the banner? And do you think it's appropriate to do either?
I don't think it's a.
Go on, sorry.
Sorry. Okay,
Go ahead,
I don't think
Scott.
it's a. Oh, sorry, thank you. I don't think it's appropriate to either ask nor tell them to take it down because that still brings attention to the class itself that the teacher obviously does not want to be something in the background to be seen. So even telling them to be taken down, so telling the student to put what's background is still just the same message as telling them to take it down. That's because all the students will easily detect that this teacher always does not want what was be shown during class.
And to go on that, I do think that there's a similarity between being asked to put up a background, mainly because if the chief purpose of the action is to block that message from being seen, then I think there definitely is a parallel to be drawn between asking it to be taken down versus covering it up in some way. And then also,
Let me ask how students would feel if there was a sort of a uniform policy that said all students have to have a certain background when they're in periods of virtual instruction. So it's not singling out any one student. Everyone sort of has the same background.
Well, I think that a lot of teachers try to make it as even as possible with the backgrounds as it is. Like a lot of my teachers require us to sit in front of a plain blank wall. And I think that that is effectively almost the same thing as having a virtual background. So in addition to that, I also think that possibly in these same classes, there are restrictions against that you can't be in a car, you can't be in front of like a window or like in your bed, because sometimes I have been in classes where students are like lounging on their bed or in a car and I'm like seeing the skylight as the car moves and it's pretty distracting. And I don't think that those examples are really appropriate for the classroom setting.
I definitely agree in that I think having a uniform banner or uniform background would be the best way to approach it because that's showing that it's not necessarily partial to people who want to express themselves. It's just a general policy of the district. I think that overall that would be, I think, a very good way to prevent any of these issues from ever happening in the first place.
So I'd like to just wrap up this question with one more, and it's a big one, and it's social media, and it's one that we kind of all wrestle with. I know as a high school principal, there's at times I wrestle with this and trying where's the line. So can you guys share with us from a student's perspective, where do you believe the limits are on student expression, time, place, and manner when it comes to social media?
Personally, I don't think it's the school's place to restrict students on what they can post on social media, unless, once again, it becomes a situation where somebody's being bullied or harassed. That is the time when the school should step in because it could leak into the way we learn and the way we experience school. But if it's anything other than that, I don't think the school really has a right to tell us what we should be posting.
On that line, I do think it's worthwhile to mention that there are potentially things that students could post about themselves on media. For example, recently there are posts about people going to parties or going to gatherings in this COVID time. And the question is, does them posting those pictures indicate the evidence of a threat that they could pose to their hybrid peers when they go to school? And so does the school have a responsibility to step in at those times? I don't know, but I think there should be some sort of way that the school can weigh in on those circumstances and prevent that danger from being to the hybrid students.
That's a very interesting example, boy, because in the age of a pandemic, we think about potential threats very differently.
Yeah, so Dr. Farinella brought up earlier about extracurriculars. Students, would you guys feel differently if your social media restriction came alongside, for example, your participation in a sport or an extracurricular? It's like I could see a scenario where a coach says, all right, an hour before and after games, you have no social media presence whatsoever to avoid confrontations with the other team or other types of inappropriate social media posting. How would you feel about that?
I don't think it would be appropriate per se, mainly because I think it's a bit of a stretch to ask all athletic students in a team to not use a facility at all under the assumed threat that they might do something. I think it's important that they have the right to do it, but also that the school should know if any exchanges do happen that potentially hindered the game after. And in that case, discipline students who did that specifically instead of punishing the whole team for not being able to use social media before or after games.
Yeah, and I think that we can even see examples from earlier in the presentation that like the courts were much more protective of the cheerleader who posted negative things after the tryout. I think that the courts would want to protect the speech after the games or anything, and I don't think that it would really, again, be like the place of the coach to restrict that.
I think that it's okay for them to suggest it, but it's not okay for them to be enforcing it when it comes to sports. But personally, I'm in this kind of a club in my school called Peer, where we have to act as a role model to some of the younger students. And we sign a contract saying that we don't do anything illegal or anything like that. So sometimes it comes to the point where some of the people who are involved in Peer go to parties and they get involved with some illegal activity like drinking underage, and somebody videotapes it and posts it. At that point, I do feel like they have a right to say something then, because obviously we signed a contract, we had a agreement, and also it is an illegal activity.
I will point out, we didn't have this in our PowerPoint presentation, but there was a case from Ramapo Indian Hills School District where the Commissioner of Education ultimately decided that a school district could not ban a student from being part of a team because the student chose to go to a party on the weekend without showing some specific evidence of substantial disruption in school. It would be very different if the student bullied someone at the party or if they came to school under the influence of alcohol. But the commissioner said it's not enough that the student chose to make that bad personal decision to say that you're now not allowed to be part of a team.
I'd like to add, when the students themselves sign up for this club, and it is our choice to sign that contract saying that we won't do anything that could say that we're not a role model. So it is a mutual agreement between the administrators of the club and the students.
So
the challenge comes if it becomes a condition to be part of a team or activity. That's where there are some limits that the commissioner has placed on those sorts of agreements.
So, Mr. Solosky, do we want to continue to move forward? We really spent a good amount of time talking about question one. Would you like to lead us in question two?
Sure, sure. First off, Minta, Jonathan, Jalissa, Scott, I'd first like to really commend you on your wonderful, insightful answers from your points of view as students and young adults. And I'd really like to continue this great discussion with the following prompt. And keeping in mind the previously mentioned Tinker versus Des Moines Supreme Court case that rules that students don't necessarily leave their First Amendment rights at the door of the school, I have this question for you. What forms of speech, whether they're symbolic or they're expressed, do not belong in the school setting? And when I say symbolic, I'm sure you know these answers, but I'm going to give you some examples. An example of a symbolic expression that would never, I'm sure, happen in the school, hopefully, would be the burning of the American flag. In addition, the kneeling during the national anthem, or sitting down at one's desk during the flag salute in the morning at schools would be considered symbolic. And express would simply mean that you wrote it, you said it, whether on paper or out of your mouth or on your shirt. So once again, what do you think as students do not belong in your high schools? There's no place for it. We can start off with whomever.
I think it depends on the diction and the tone of the students who are speaking or expressing themselves. Yeah, that's really it. Like as long as they're not, I hate to repeat myself, as long as they're not harassing, they're not bullying, or they're not endangering other people around
Well,
them.
How about this, Jalissa? You've been at Rahway High School for 4 years, and of course we have to keep confidentiality in place. Have you ever been offended by some sort of expression, whether it was symbolic or expressed, while you were in school, where you felt that is just inappropriate and it has no place here at Rahway High School?
Personally, I can't really think of an example where that has happened to me.
Well, that's a good thing. Scott, can I ask your opinion, please?
I also agree with Lisa that I haven't seen any cases like that. The closest thing would be to a case is somebody just wears just a dress code policy, but even that is not a huge issue to me or to any disruption for anyone.
Okay, very, very good. How about Jonathan and Minta? What are your views on what, certain forms of expression that do not belong at East Brunswick High School?
I mean, I would like to say that I agree with the current sentiments being expressed, but there is like one specific instance where I'm not sure if it necessarily belongs, but so I don't know. So the issue, I guess, would be with recently I've seen certain students wearing either masks or shirts where they're wearing the police flag or the flag with the blue line through it. And this flag has been slightly controversial. It's been seen by some as solidarity with the military profession, but others, it's also been flown by certain white supremacists. So I guess the issue with this is that there is possibly not a current direct message on the masks, whereas more of like a Confederate flag would obviously have a much more hate speech strong message. So I'm not sure if necessarily this would belong in a school.
What
That's a
Minta
very
said is, yeah, it's really important because things evolve over time. Something can end up becoming a form of hate speech over a period of time where it wasn't yesterday or a week ago or a month ago. So that's a very interesting point.
Would it be safe to, okay, so does it matter what the context of the scenario is? For example, I know you're mentioning the masks, but we do see, I guess, the Blue Lives Matter, with the police officers, where people wear shirts and they have the flags, so forth and so on. Would it be a problem if a student wore that shirt or that mask to school in response to the Black Lives Matter movement? Would it be provocative? or does it not matter at all? It's so controversial nowadays. What do you think?
I think students should be allowed to wear shirts again without hate speech or specific HRB, in that requiem. But I also think that it's important to understand that I think it would be hard to see if a student specifically wore it in response to it. I think the intent of wearing that shirt would be hard to figure out. But I do think that, I mean, again, with the previous cases of Stepniewski being able to wear a shirt that had a political message, I think that it should be allowed. Again, as long as it's not that person trying to yell across the hallway saying that that's the case. Just wearing a shirt in itself, I don't think is much of a problem and should be considered a protection of the First Amendment.
Okay. And Jonathan, may I ask, I don't remember if you answered this. Have you ever come across any situations where you've kind of felt uncomfortable with someone else's freedom, their use of expression, whether it was symbolic or explicit?
I haven't necessarily seen any BLM shirts or Blood Matter shirts in the recent few months, but I would say that there have been shirts, like for example, regarding the Second Amendment, where someone wore a shirt saying the Second Amendment is my permit to use a gun or permit to own a gun, or shirts like that, which didn't make me feel any certain way because again, that was their opinion. But I do think that someone can be offended by that, but I don't think that classifies under hate speech because they weren't necessarily trying to offend or lodge complaints against a specific group of people on their race, color, so on and so forth.
Wow, what a great observation, Jonathan. I'm very curious to see what our experts say about a Second Amendment shirt, maybe an NRA shirt or something.
You know, certainly you would have a right to express your views on issues of, you know, gun control or your right to own guns under the Second Amendment. You might be crossing a line if you're suggesting that we don't have to obey the law when it comes to something like, you know, having a permit in order to have a gun. So there is at least that implication in that shirt that was just described, that somehow we're suggesting you don't need to follow legal requirements. Then I think you might have a different analysis.
I can give you an example. A number of years ago, there were these two girls, and I forget which school it was somewhere down south, I think. They pretended to be the Columbine murderers. And so they took pictures of themselves holding their guns back to back, paralleling the exact pose that everyone saw of the Columbine killers. And those kids ended up getting in a heck of a lot of trouble. That's very different than saying, I support the Second Amendment.
I think in that case, the threat of that picture was a clear and viable threat as compared to a shirt just saying that they believed in a certain political side of things. So I agree with that.
And as a continuation of my question in regards to freedom of speech, we have been, for many of us, not all of us, in a virtual environment for 6 months or so, if not longer. Do you foresee things when we get back to normal with everything that's going on in the world today? Do these issues, are they going to be more contested? And I can really say that for my students, Jalissa and Scott. We haven't been in the building, and a lot has happened over since the pandemic broke. What do you foresee that our principal may have to deal with, or administrative staff?
Well,
For example, might students want to express themselves on issues of political or racial injustice?
well, I feel like right now everything's very hot. So that's why all of these topics are coming out. By the time we go back, we're scheduled to go back in January. I feel like by around that time, things might be died down by then, but there'll definitely still be topics.
There's certainly a chance that they're actually increased possibly in January when we go back, because that will be the time when we have, whether we have a new president or a re-elected president.
Can I just drill down on a comment? I think Jonathan brought up the Second Amendment, and it kind of remained, we're talking about freedom of expression in a sense. And you know, a couple of years back, there was, when we did have, unfortunately, we saw several school shootings. and there became a student movement or expression regarding the Second Amendment and gun rights. And we experienced, and I know Jonathan and Minta can talk, we experienced it right here in East Brunswick High School. And there was a walkout movement, an expression movement. Do you think that is viable and responsible? Or freedom of expression?
I think.
Yeah.
Sorry, go ahead.
Okay, sure. I think this is Minta talking, and I think that the school's response to the students wanting to protest at that time was a very smart move by the school.
Thank you, Minta.
Yeah, you're welcome, Dr. Vanilla. And that in doing so, it allowed the students to express their views but the view was mostly it was only focused on what was in line with the school and protecting the school. The administrators didn't address any partisan issues with it. It was just about protecting the school. And I think that in listening to what the students had to say and helping them perform this movement in a peaceful way with them really helped maintain the trust with the administrators. And it also helped the protest and the students express themselves in a peaceful way, and maybe moving forward, then they'll have this good example behind them for the appropriate way to handle certain pressing topics.
So as an example to that, I think a few years ago we had a pep rally half day kind of thing where we had a pride celebration. And I think in a similar way, that's a very smart move because the school does uphold values of equality for all. And so I think having that is a way that school can put forth that its students believe in these values. And I think that as long as the message being promoted by the students is not directly interfering with school values and it is interfering too much with the school in itself, I think that it should be allowed, and the school might be even benefited to sponsor or hold such an event for the students.
May I piggyback that, please? Under the leadership of Dr. Farinella, who was here today, who was the principal at Rollway High School, Rollway High School also had a peaceful protest after the Parkland shooting. So Jalissa and Scott, you were in school during that protest. So my question for you really is, because I was there also, number one, is it the school, how should the school respond to students who would like to engage in these peaceful protests? Number one, obviously, Rollway High School was very open and conducive to this peaceful protest. But what happens if Dr. Farinella would have taken another stance and said, this is not the time and place for us to do it. We're an institute of education. What are your thoughts on that protest that we had in school and how it could have gone the other way?
Well, I think the way that our school handled it was very, very good, because what people wanted to do, they said that they wanted to march out, but that did endanger the students, being that publicly saying that we are going to walk out of the school on that day could cause a target on us. So I feel like it was very, very responsible of the school to handle that and to keep us inside, but also allowing us to express ourselves and to protest in such a respectful way. To the second part of that question, not gonna lie, I don't really know how to respond to that. That's a much harder question to answer.
Well, Jalissa, what do you, without speaking for yourself, how do you think the student body would have reacted if Dr. Farinella would have said, listen, you're suspended if you partake in any form of walkout or protest? And Scott, you may certainly answer that. And certainly Minta and Jonathan, you can jump in also.
That's a very difficult question, so I'm gonna have to hand it off to my.
What do you think, Scott?
I think in that regard, along if what the plan of protest does endanger the student safety and others, then the principal does have a right to enforce that kind of rule. But if it's going to be a peaceful protest in any sort of way, then the principal is overstepping his rights on the students to suppress them for peacefully expressing their own opinions.
Well, to piggyback off of Scott, I'm not saying that he's wrong. I can argue both sides for this situation where the principal can also argue that it's disrupting class time and other students who actually want to stay in class and learn. So that's the only reason why I'm having a very difficult time answering this.
Yes, I had Jalissa for AP US Government, and she always played the devil's advocate. So she goes back and forth. So you're very empathetic, Jalissa, of both sides of the students that would like to protest and those students that feel that, you know, there's a time and place to protest, but you were there for educational purposes.
Jalissa, every good attorney can argue both sides of a question, so you might have law school in your future. So,
So there's a lot of good discussion here at No Untempered, but we still also have some other great questions that we wanted to go about covering. So if it's all right, I'm going to move on to the next one. And we talked about not only the freedom and rights of speech of the students, but also during our great opening conversation had that of our teachers too. So I'd like to pose another difficult question to you guys. What do you expect from teachers when discussing controversial issues like religion, politics, lifestyle choices, or other controversial topics in the classroom setting?
I think I would expect above all being as objective as possible. I think especially when it comes to controversial things, teachers being objective has a very good impact on the classroom. For instance, in 8th grade, when we were talking about in the 2016 election, my teacher in history clearly mentioned in the beginning that he is not trying to give us any of his political views, and we just wanted to cover how the election was going and what was exactly happening. And I think statements like that and a view like that of trying to be as objective when concerning these matters is a good way for teachers and for the school to progress its education objectives.
Oh, sorry, you can go, Minta.
No, you can go.
Well, personally, I feel like the teachers should not only be unbiased, but they should definitely be able to argue both sides. They should be able to teach us about all different points of views of the argument at stake if they decide to bring it up. If it's in a classroom like math, it should not be discussed at all, in my opinion, because you're intruding on the lesson and what we're supposed to be learning in that class. But if it's a class like government or law that has to do with the actual controversial statement at place, then, like I said before, they need to be able to teach us about every single point of view, because it is the teacher's job to teach us how to think rather than what to think.
Yeah, to go off of that last point, I think that it's really important that teachers also try to get the students to come to their own conclusions and not refrain from asking leading questions or specifically only highlighting one point of view and being like, this is the answer for like the test. That I think that it's important that students are able to navigate these tough issues on their own. And to that same point, that it's important that teachers don't sidestep or I think avoid the controversial issues altogether. We need to be able to talk about them, I think, in some way and help us better navigate people who feel possibly the opposite perspective, and also help us, to that point, improve our argument and really see from all sides of the argument.
So come on, Minta, Jonathan, Jalissa, Scott, you never pushed your teacher. Upcoming election, hot election. You or any of your classmates never pushed one of your teachers. Come on, who you really voting for?
Oh my God.
Definitely not, because that would not help us. And I feel like that can also put the teacher at risk, because if they come out and say that they do support candidate A and there is another classmate who supports candidate B, then that can cause a real problem for that relationship between the student and the teacher.
Jalissa, you're speaking for yourself there, which I really appreciate, but have you never seen that done before, where, especially in a history class or a government course, where students, instead of being taught how to think and come up with their own decisions, where they push the teacher? Well, what do you really believe, Mr. C, or whomever it may be? You've never seen that before?
Well, not blatantly and outright. Like maybe they had a conversation that started leaning towards that, but I've never really seen it like blatantly said like, well, who do you support?
Yeah, maybe I'll jump in here because I can promise you Minta and John have been in classes where that's happened, because I know that that's been asked of me. Minta and John, what was your reaction when students are like, oh, well, just tell us, just tell us?
I think with Mr. Mondry, it's an actually very good example of what he does. I think in general, Mr. Mondry will tell us all the facts of the situation and generally make us give him a response. And the way he shows objectivity, I think, is impressive, where no matter what we say, he will ask us a question to challenge us and make us improve our thought process. And so I think that in general is a very impressive way of showing objectivity in being able to make your students improve their thought without providing a clear-cut answer to their question sometimes.
Yeah, this is Minta speaking, and I think that I've had classes where teachers didn't even need to be pressed to really explain their political views, where teachers have been outright with they're on this side of the spectrum and they've talked about issues for almost the entire year. And I think that in those cases, it did at times make the students who disagreed with them feel uncomfortable or not willing to express their opinion. So I think that it's also important, though, that teachers or that students recognize that almost like the news, almost all teachers are biased in some way or another. It's very hard to find an article that doesn't have some of the writer's own perspectives. And as long as students are able to identify sort of a political bias and seeing which teachers are more what way, and then able to see what the knowledge or what the lesson is actually trying to teach for what it is and not for what the teacher is trying to make it seem like by putting their own opinion in it.
Minta, may I ask you a question? With everything that we've learned about today from the legal experts, do you think, beyond appropriate, should the teachers have been allowed to do that? Or should you be, as a student, should you be able to say, okay, they're pushing this on me, but it's my responsibility to tune that out and try and get the message of the lesson?
Well, I think that teachers should have at least some encouragement from administration to not reveal their political opinions, and that the goal should be to be as biased and as clear cut as possible. But at times it is hard to like draw the line where the political opinion is. And I think that in those cases, it is kind of an inevitable part about talking about certain politics and certain controversial issues.
So, Mr. Solosky, we seem to be slowly migrating over into question 4. We're bouncing back and forth. Do you want to share that question with everybody?
Yeah, absolutely. So expanding upon the previous question, do you think that, and there's 2 different scenarios here, do you think that it is okay for teachers to offer their personal opinions outside the classroom, but during a school-sponsored function, such as a football game or a concert? And number 2, and this is the real tricky one, what happens if you see a teacher off school hours in a place such as the park or the supermarket? Is that teacher your teacher, or is that person a possible friend of yours? And are their views restricted even in the supermarket?
The first question, I would say that in a school setting or a school-sponsored function, the teacher would be still bound by the rules of their professional responsibilities in not being able to completely divulge their opinion. But I would say that if I met a teacher outside the school at, per se, the supermarket or something, and I think there's a difference in how that conversation would go. For example, if I were to meet them and the first thing we talked about was just politics, and that was the whole discussion, that wouldn't bother me, but I would say that's different from if we were talking and politics happened to be part of the conversation or it happened to slip in. So I think it's different, and it should be examined as to what degree of conversation is being had and what degree of pushing on politics is being done by the teacher on the student when discussing outside of school exchanges.
Well, Jonathan, if you saw me in a supermarket and we knew each other, and I started up a conversation about the 2020 election, and I voiced my opinion, who I liked and I disliked, and I tried pushing my opinion on you, outside of the school arena on a Saturday or Sunday, or maybe over, a break. What do you think? I know it's different, and you said that very clearly, but is there a student-teacher relationship when it comes to politics or other, let's say, controversial topics?
I would say
And
that's
this is while you're a student, not when you graduate. I'm talking about while you're in high school.
yeah, I think that's an awesome question, mainly because I think if you were talking to me as my teacher, I would appreciate talking to you about, the difference and debate. But I think it's a different conversation to be had if I'm potentially scared of my grade or my performance in class being affected by a difference in opinion. If I know you to be a teacher who, loves to talk to students and loves to have debates, then I would freely participate and freely come in knowing that, I have my own opinion. But if I was scared of my grade, or if I was scared of my performance in class being interrupted by this debate, then I would perhaps have a different opinion.
So Jonathan, just to clarify, if I was a big Trump advocate and I was to see you in a supermarket and I said to you, oh man, you're going to vote for Trump, right? You're put in a position where you're possibly worried about your grade being affected if you said to me, Mr. C, how can you say that? I'm a
Right.
Biden man all the way.
I mean, I would say that if you were to ask me, I would tell you that, I have my own opinion and I would tell you that. But again, I think it's a different conversation because I feel like if I knew you as a teacher, I would think that you're a very impartial person. And I would think that even if you told me that you would not let that ever leak into the classroom or into my grade book. But I think a teacher who does pose a threat to a grade book or does put that in the discussion is a different discussion and should be reprimanded or disciplined by the administration.
And this goes to you, Jonathan. This goes to Minta. This goes to Jalissa and Scott. How do you think the court should see that predicament happening? How should they rule? If outside of the school, possibly on the weekend, in the supermarket, on vacation, it could be your next door neighbor.
I would say it gets kind of tricky. You have to analyze how exactly the student felt in that scenario and potentially ask them if they felt as if they were being compelled by outside forces like grades or by threat of performance in class to think a certain way as compared to if the student felt that they were just having a discussion with the teacher.
How about the other three? Minta, Jalissa, and Scott, what do you think?
Well, for me, it's more like if I catch a teacher outside in a non-school zone and we're in a supermarket or something and they're wearing a t-shirt that simply says what candidate they're supporting, I feel like that's one thing. But if they actually like come up to me and start the conversation and actually like start advocating for it, I feel like that's a different story.
Do you think that is punishable? Do you think the teacher should be punished?
I don't know about punished, but I feel like they should at least have some kind of, I don't really know. This one's really hard.
I know what you're saying, Jalissa. They should, and I think everybody here agrees with you that they should not do something like that. But unfortunately, as you have heard today, educators aren't perfect people. Most of us are, but some of us aren't. And we do make mistakes sometimes. And if a teacher does make a mistake and crosses that boundary, if it is a boundary, what do you think should be done? And Scotty, feel free to answer. Minta, please feel free to answer. Or should they're on their own time. They're not on the payroll. Should they be able to do it?
You're not on your payroll, but you're still talking to someone that you're like, you have a job. You're still talking to someone that you have to be in class with.
So if I could just step in, because I know we're coming to the end of our session, but I thought it would be pretty nice to give Minta, Jonathan, Jalissa, and Scott maybe closing remarks. There's still plenty of people that are on listening to this. From a student perspective, what do you want to know? What would you want to your teachers, your administrators, whoever else in the educational setting to know about what your thoughts are with regard to First Amendment rights or anything that we talked about today.
I would say above all, I would like to have my own opinion. I would like to be able to discuss it and discuss it insofar as it doesn't cause a disruption to other people. And I would like to talk to people, talk to teachers too about different issues. And I think that we should be able to have that exchange, especially in a country where we are responsible to be educated citizens about our government and our politics. And so I definitely want to be able to have those discussions, but keep it civilized and keep it to an extent which doesn't cause the other aspects of education to be compromised by that same thing.
That's safety, huh? Not necessarily physical safety, but the safety to speak, right?
Exactly, right.
Mhm.
Minta, Julissa, Scott, closing thoughts? What do you want to tell everybody?
Yes, I think that Jonathan expressed it almost word for word, probably expressed it better than I would have said it. But I do want to add on to what he said, that I think that the administration has been, for the most part, doing a great job in trying to respect student expression and allowing us to be able to express our views. But I do also think that it's important for the administration to keep moving and recognizing that our political and our world is always changing, and it's important for us to be able to keep up with the virtual environment and social media and the trends on social media possibly affecting the classroom. And also, I think that it's important that the administration make sure that speech is protected so that we can talk in civilized manners and be those citizens that Jonathan talked about, and be able to recognize a lot of views so we can make the best decisions for ourselves as adults.
Definitely, I agree with that 100%. I feel like as students, we should be encouraged to be able to express ourselves in a respectful and mature manner, but we should also be mindful of why we go to school and what our job is in a school environment, where we should be focusing on the lessons that we're learning while also being mindful of what is going on around us.
Scott?
I agree with everybody was said about freedom of expression by students. So long as it doesn't cause any disruptions, because students' freedom of expression does show a higher level of education to have this type of conversations, so long as they don't get out of hand. And I do believe that the administration has been doing a fantastic job since, and that anything can happen, and those could be a situation where it be on the fence. But other than that, the administration was doing well, and yeah.
Thanks.
Before I'm done speaking, I just would like to say how proud I am and just amazed at the job that Minta, Jonathan, Julissa, and Scott did today. You did a wonderful job. I'm so very proud of you. I've learned quite a bit just from your answers. And I think all of us here, whether we're administrators, teachers, students, or just if there are any other parents here or panelists, it's always super important to hear the student's point of view. And you did a wonderful job representing the student body of not only your high schools, but of students in general across this country.
Mike,
We
I
agree
would
with that
agree.
as well.
I'm sorry. I would agree with that. And, you know, all the stuff that you hear out in the media, social media, this or that, boy, after hearing these really bright young men and women, you know, the future is definitely bright. Mark, Mike, thank you for all you're doing in the classroom for our students. All your hard work is there. And it's no doubt, this is just one instance to understand is why New Jersey has the best schools in the country. And finally, thank you to PSA, NJPSA, for holding this event. I learned a tremendous amount, and I hope that those on the line did as well. Thank you very much.
Thank you.
Yeah, as we're wrapping up, I just want to, add my thanks. It was an incredible discussion. There were so many insights coming from Minta, Jonathan, and Julissa and Scott. The depth of your conversation, I think, was just wonderful. And we were able to tackle a lot of very difficult issues I know that in this difficult political season, we don't always have great role models with our adults, but I can see the incredible work that is happening in each of your high schools. So thank you so much for everything that you're doing. Thank you for all of our panelists today. I think it's been an incredible discussion from beginning to end. And just a reminder for everyone who's part of today's panel, we will be sending out the recording from today's discussion tomorrow, and the PowerPoint that we use. So we do hope that others will get this information out there and just help us to have this kind of responsible civic discussion as we all move forward.
And
So
David,
thank
on
you.
behalf of the lawyers that are online, I just want to thank you for putting this together, and thank Sandra for putting together the for assisting in putting together the webinars. It was terrific.
Thank you, everybody. Thank you, everyone. It was a great day, great presentation. Everybody be safe and be well, and I look forward to seeing you on a future webinar. So thanks so much, everyone.
Thank you. Thank you.